the recommendation of those groups. The Office of the Defender General had two separate proposals. One of them was to eliminate the list of offenses and require all offenses of children under the age of 19 to originate in the juvenile court. And that would further limit the offenses for which 14 and 15-year-olds could be transferred to the criminal division. And they have their beliefs as to why that's an appropriate position. They had a second proposal that was predicated upon, again, the lack of consensus on whether things should be added or removed. And their view was that even though there was no consensus, that there was still enough, I used the word in the report, interest from the various stakeholders to change the age at which the Big 12 applied from 14 to 16. And there were a number of committee members who did agree that requiring 14 and 15-year-olds to be charged criminally for even serious offenses were inappropriate, and that the legislature could raise that application of the statute for the transfer. Now, that is not a sentencing commission recommendation. It's a proposal by the Office of Defender General recognizing that during discussions, unlike some of the other areas, this was an area there seemed to be, if you will, a little bit more ability for the parties, for the members to have some commonality, if you will. And so that is something that you may...
So I understand 14 and 15-year-olds would be dealt with in juvenile court, but could be transferred up if they was a murder, for example.
I'm looking at Marshall because that is what I understood the proposal to be.
So transfer up and rather than down.
Correct. That was the proposal that was put forth. And so that, I'm sure you're going to hear from the stakeholders on that aspect. The other issue that we touched on was the burglary into an occupied dwelling.
Yeah, that is a thorny piece of
the commission considered that question, and there was a consensus by the commission that there is a difference between a dwelling that is occupied year-round as opposed to a seasonal dwelling that may not actually be occupied at the time of the offense. Some members of the commission supported having an alternative or redefined version of the offense in 5204A to address the unoccupied seasonal dwelling issue. There was no motion, however, made to make that change, but that's a policy decision for the legislature, and the commission does think that that's something that the legislature should consider.
Personally, I think it's something the legislature should consider.
So if there's any questions, I'd certainly be happy to address them.
Personally, was there any language put forth on that, on the occupied dwelling?
There was not.
Judge, do you have any thoughts on how this would impact the backlog in any direction, or any opinion on that?
I can't say that it's going to necessarily make a significant impact on the backlog.
Okay.
If we have cases, on one level, if we have the cases all going to the juvenile court, and there are certain cases that are not going to be transferred up, possibly, that just has us doing the case in that court. Mm-hmm. If they're transferred up, we're doing it in a different court. It might be one less hearing, but I don't know that it would have a significant impact on the backlog because we still have to address the cases.
Right. I think the thing that I was thinking of is how is the number of cases that get transferred from criminal to family. And I think we're waiting for the data on how many cases get transferred back and forth. And so I was just thinking about just the number of motions that have to be filed. If we're adding more, then it will create more instances of filing motions to transfer from criminal to family. So that's what I was thinking.
It certainly could, but my thought is that we're going to have to allocate resources to one of the two dockets anyway. And I think that's something that can be addressed.
That last year in S4, didn't we deal, Marshall and Erica Martin worked out some language on the ping pong effects of going back and forth, and I don't know if that's helped or hasn't helped.
I understand there's some additional discussions going on about that to try to address that.
This bill could be a vehicle for that additional discussion. If the state's attorneys and juvenile defense group can come together on anything we can do to help reduce the cumbersome nature of going back and forth between family and criminal. Senator Bohowski.
Thank you. So I guess as a follow-up to Senator Hashim's question, sort of thinking on the other side of this of sort of presumptively starting more of these cases in family court, as the Defender General has suggested, I'm confused how sort of streamlining that process and having less motions to move things around would not have a net positive impact. You know, we had one of our judicial nominees talking about like eliminating those sort of motions hearings that don't really get us anywhere. So I guess I'm a little confused how eliminating some of those motions with a presumption that they'll start in a certain place and fewer of them will be transferred wouldn't help with the court backlog.
I don't know that there's going to be as many cases as would make a notable impact. So is it potentially something that having X amount of cases causes extra work? Yes.
Okay.
But I can't sit here and say that if that happened, that it's going to absolutely cause so much more work, because I don't think that there's the numbers of cases that will generate those issues.
And I had a follow-up.
No, there's also the reality that no matter what we do, the lack of replacement options for DCF is going to screw the whole thing up.
Mm-hmm. So my follow-up is sort of,
until they solve that.
sorry. My follow-up is sort of the inverse to that. So what the Defender General's office is proposing is presumptively starting more cases in family court. Yes. Would that potentially have a streamlining and positive effect on the backlog, or are you still of the opinion that there just aren't enough cases for it to have that much impact?
I don't know the specific numbers of cases. Could it potentially have a positive effect? Every case that we remove from needing judicial hearing time brings with it the potential for a positive impact on the backlog, but I don't know if it's a negligible impact or a significant impact.
Okay. Your crystal ball is not working today.
No.
Okay.
Other questions for Judge Zolnay?
I was just gonna say, when Matt Valerio ran out this thought experiment, what if all of these cases started in the family court and we transferred up rather than the reverse? It makes immediate intuitive sense to me. So I think what Senator Bohowski is trying to get at is, are there complications we're not foreseeing in the way you use judges to fill the docket? Does it in some way, because to the person from the outside, it seems like it would have to result in fewer transfers, for instance, because going the other way, the presumption just seems to make sense to me that it would eliminate a lot of the switching of courts. So can you say anything more about the logistics that it might create, logistical problems or logistical easing, if we went to that?
The model of starting everything in the juvenile court.
Yeah, so in other words, no Big 12 exceptions.
Well, I think earlier on in the session, you asked a question of me, and that question you gave me a number of choices, and one of the words was simplified, I believe.
Mm-hmm.
And my view at that time, and I remain of the opinion, and that is, if everything started in one location, it simplifies things.
Mm-hmm.
And that's a policy decision.
Mm-hmm.
Is the simplification that you would be gaining something that the legislature believes is appropriate for a policy standpoint?
Well, I'm sorry, go ahead.
Sure.
Yeah.
Okay. And so when you look at that policy, the question that I have is, well, would it simplify things? Yes. And why? Because we're sitting here having discussions, and this committee is taking up discussions time and time again about what's going to be added. And then when a child is charged with a crime, what happens? The attorneys will tell you that they're saying, okay, we have to go to 52-0 and we have to go here. I mean, can we charge here and where do we go? And Eric Fitzpatrick gets questions. And so if that happened, it would be much simpler.
Mm-hmm.
But the question is that simplicity a policy decision the legislature wants to make?
Mm-hmm.
If it was there, as from a resource standpoint, and we saw that there were more cases coming into the juvenile court, we would allocate appropriate resources. One of the requests we have this year is for a statewide juvenile judge as a float. So that type of resource would be precisely what we would be able to utilize that judge for, to be able to respond.
And if I could just add in, so simplicity would be one thing, but the other thing we've been talking about and concerned about is the idea that with these cases, they start in the criminal court, there's a record established, that's out there on the internet, then it gets transferred maybe to family court, goes under seal. So the worst possible charges are out there, but then maybe in family court, they get reduced or they get thrown away. Those are never available to the public. So this thought experiment from Matt seems to be that it also deals with that issue, which is that this whole class of folks would be initially protected from public scrutiny unless it was determined that they were going to be transferred up into the criminal division.
That is a byproduct of that policy.
Yeah.
Well, I just remember that a delinquent act is a delinquent act. So once they're in juvenile court, the murder becomes delinquent act, just as the shoplifting becomes a delinquent act. So it doesn't matter. Take one. And also, you don't have a right to a jury trial. But when you have a very serious case, murder, for example, drug trafficking under a new scheme, I think it deserves, personally, I think it deserves a adult court, but I consider 14 or 15 probably. But if you're committing murder, and you're alleged to have committed a murder, you're charged for that in adult court, and the court decides to move it down, at least the public has had a voice, has had a say, as the victims community has had some kind of a voice and had a say. I'm really concerned with starting everything in juvenile. I don't know if there's a way to protect the name if the person's under 18, for example. But I don't think there is, if you're charging an adult court. Those are some of the problems that I see if we go in that direction. Senator Bowski and Senator Norris.
Thank you. So, and this may be a question for you, Judge Donate, maybe a question for Eric. I'm not totally sure. But under the sort of conversation we were having, for the, as you put it, Senator Booth, the thought experiment with Matt Valerio, there would be nothing to preclude the prosecutor from deciding to transfer up into criminal court, correct? It would just not necessarily start there. So if a juvenile is charged in family court, the state's attorney says, this is a murder, this should be charged in adult court, they could make that move.
My understanding of the proposal that was made, and again, it's a policy decision for the legislature, is just that, is that it would start there, but that there would be mechanisms for certain cases, as the legislature would decide from a policy perspective, to move up.
Right, and that would protect the privacy of the juvenile, sort of with the worst possible, it would only become public if it got moved up rather than being public and then potentially being moved down and like being a black hole of information, correct?
We have confidentiality under statute in the juvenile court.
Okay, great, thank you.
Yeah, Judge Nona, if memory serves me correct, when we were speaking about expanding the Big 12, I believe we took testimony on this issue as far as moving individuals from family court up and vice versa. And I believe someone had stated that, and we were concerned at the time of if a juvenile was trying to get moved up or was trying to get moved down because of the lack of resources we had for facilities and so on and so forth. There was a concern, and I believe we took testimony that it doesn't happen all that often, but it's much easier to move someone from criminal to juvenile family court than it is from family to this time that right now, I don't know if Marshall made that, but someone said it takes a little bit of time to move from family up to criminal court. And now you want to put more folks in that.
It takes time on either side of the equation. I haven't done any type of data analysis to determine which one takes longer.
Okay. Any other questions for the judge? Judge, thank you very much.
Thank you.
Tomorrow's hearing, you're going to be remote, so please check with that on that. We do have one witness who would like to testify on one particular judge, but I'm not sure which judge. So we will give that judge an opportunity to, respond if they wish.
Would the judge respond tomorrow or
I
would
think
we schedule a
probably
separate time?
waiting for another week.
Okay.
Schedule it a week from Friday.
If I let the judges know, I'll touch base.
Yeah, I'm
with
just,
them.
if we can find out which judge, just touch base with Ben, and I'm not clear which judge the witness was.
And if it's okay with the committee, I'll tell the judges Zoom works for them to sign in tomorrow if they'd
Zoom
like.
is fine for all the judges. I don't want somebody driving up for Barry.
You wrote the minute.
The dangerous track from
That's a
there.
long drive.
Yeah, I meant betting.
So, thank you. Have a good day.
Thank you. Our next witness scheduled is Timothy Waters Dumont, who is the legislative and assistant appellate attorney for the Vermont Department of State's Attorneys and Sheriffs. Tim?
It's good to see you all. Tim Leaders, Dumont, Department of State Attorneys and Sheriffs. And you've already asked all the good questions of the judge, which is why I always prefer that he goes first, just so Ben knows. I always appreciate him going first.
Always have the judge go first.
Yeah, and then exactly, always have the judge go first. But in terms of this bill, just from the outset, we're supportive of the bill, both the gun provisions and the section that you were just talking about. Last year, this committee did some good work on guns that we thought was helpful. We see some of the gun provisions as a continuation of those efforts that you were talking about this morning, and also appreciated that you had some experts in to talk about what some of the mechanics in that bill are. In terms of the upper sections, we have seen, and I'm going to work with our Bennington County folks, Senator, we have seen the most ghost gun-like seizures and also observations of ghost guns in Bennington County.
Figures.
And we have also seen some in Rutland and Addison that have been taken on by the federal government. And it's interesting because I also asked the I-91 corridor, and there was less on that corridor, more on the Route 7 corridor. So I don't know if the mountain is a helpful deterrent at the moment. It certainly can be an interesting deterrent.
My understanding is most of them use rental cars. Most of the drug traffickers use rental cars.
We've seen that in some affidavits in Bennington, yeah.
And they go to a licensed firearms dealer. And the licensed firearm dealer looks out the window and sees 3 people in the car, and then one Vermonter comes in to buy 3 firearms, a variety, and then the licensed firearm dealer says no. And they go to the next dealer. It's more difficult to buy the guns for drugs. So they produce it.
And I would agree that there's underreporting, as I think the senator from Chittenden was discussing.
But I thought it was everywhere, but I thought Bennington, didn't realize Bennington was as prevalent as it is.
And I'm still asking around a little bit, but I know that there's been the highest prevalence in terms of.
But I think it's like anything, it's just beginning, and it's better to try to get at it before it blossoms into a full-time industry.
As to is there any questions on that first section relating to ghost guns? As to the last section, we see this as a continuation of some of your work as you passed last year, S4, before it went over to the House in terms of the expansion. The one comment I was going to make is you did include the or attempt to all of the Big 12 last year. So if you are going to move forward with expansion for consistency, you would want to include or attempt. Yep. Sorry.
So I'm curious, I've learned a lot more about the Big 12 over the last year, and I'm trying to figure out intent here. Can you share with me, if this is your opinion, I mean, are there shortcomings in the family court when it comes to these cases that there's now a need to have them start in criminal court? Yeah, I'm trying to figure out what is the reason for having these originate in criminal court?
The answer to your question is yes, from our perspective. And there is a case that's currently, it was in the news and it also is in adult criminal court at the moment, but a case in Chittenden. And I did speak with the prosecutor this morning, handling that case of attempted murder. And the prosecutor was able to move quickly to have a hold without bail in place for the victim and for the community. And that individual is over the age of 18 years old, is charged with a Big 12 in adult court. And the ability to move quickly on a case like that is, I believe, some of the, and again, I wasn't here at the time, but some of the policy reasons for origination. And just something to, a conversation point that I often like to bring up is that there are many cases that we cannot talk about that are direct filed in the family division that are Big 12s. And so prosecutors are exercising their discretion, even though the presumption is in criminal, there are many direct files into the family division. In that situation, the prosecutor exercised their discretion to originate the case in the criminal division, and there may well be litigation to transfer down, as you were talking about, Senator, as opposed to transferring up. And one point from the last conversation is I talked with some of our juvenile prosecutors, and I've heard ranges of 3 to 12 months for the transfer up. So that is something that if it does start in family and it's a non-Big 12 felony, for example, and there's a transfer up motion, there isn't that expediency in terms of conditions of release or hold without bail. In terms of
So you can't use hold without bail family court for any of these offenses?
I might let Marshall talk more about the detention opportunities and pathways in the family realm.
Placements for,
But one of the greatest obstacles is the lack of placements at the moment. And I know there's work in that area that both myself and the Defender General's office are involved in with DCF in terms of a working group. But there are limitations, certainly. And, I think it's an important part of the equation right now that's not a part of what we have available to us right now in terms of that custody or detention. Yeah. Thank you.
So two things under the thought experiment, as we keep referring it to, would there be anything to preclude a prosecutor from direct filing into criminal court? Like you say they now do with the Big 12, there's a presumption they'll start in criminal court, they can direct file into juvenile court if they choose to. If we started everything presumptively in juvenile court, would there be a way or a mechanism that we could create to say that the prosecutor can use their discretion to direct file a case into criminal court?
That would be a policy choice for you all.
That's fine.
If you wanted to create like a Big 12 or a big list, whatever, of cases that we could direct file into criminal, something that was discussed last year, and I was trying to jog my memory and I couldn't find my notes on it before coming in, was the idea of a sealed criminal proceeding. It's not contemplated in current law, but a sealed criminal proceeding for certain cases. I know the governor's office had recommended that, and that's maybe a way to think about shielding that initial exposure. And I can't exactly remember where that left off last year, but it was something that was brought up. It was in I think the governor's list of proposed ideas.
Well,
Jay Johnson.
They wanted to seal everything and get rid of expungement.
I'm using sealed in a different
Yeah, but
way.
I don't remember a separate proposal.
yeah, no, they wanted to seal, but have the information available to law enforcement.
Yeah, in terms of sealing expungement, in terms of the juvenile conversation that were happening, I think it was maybe brought up in this committee last year, the idea of having the original Big 12 type of case be sealed in the criminal division in terms of the actual proceedings. So the press and et cetera couldn't come in. And then after that day, if it was determined, during conversations with defense counsel, et cetera, and the judge, you know what, we are going to put this over in family today, or, oh no, we're going to keep this in criminal for now and we'll litigate it. That was a conversation I think that came up last year. I was talking to Jared Bianchi last night and he raised that with me.
Okay.
Seems, so I do have another question. It seems sort of burdensome and complex when there's a simple solution and possibly unconstitutional.
It's horrible.
Anyways,
The victims. of serious.
I thought we weren't supposed to stay simple in this committee. I'm trying to
Well,
stay away from.
my other question around like the time frame of transferring, is there somewhere within the court records where there's like data on that, or is this just sort of anecdotal? This is how long I feel like it's taking.
Those are from conversations with prosecutors that I have that are working in this area, where they said they've had cases where I think Judge Zone in the court, I don't know if they can get how long it takes. They would probably have to find, the petition date or offense or the filing date. And then if there was a petition to file up, they'd have to just do the math. It would probably take some math from the judiciary, but there's probably a way to figure that out.
Yeah, I just want to be careful because like, I know for me, like the sort of most extreme things are the things that stick in my head. And if someone asks me, I'm gonna be like, oh, it's taken 12 months. And that might've been one case. So I just want to be careful that we're looking at the data and not.
But that one case could be incredibly important.
I'm not saying it's not important. I think the overarching data as opposed to the outliers is really important to look at. And I know humans are fallible. We tend to be impacted by the sort of extremes.
Right.
So I
No, fair point. Yeah.
But I wanna bring us back to what is going on and why I would be considering, other sponsors of the bill presumably would be considering adding these 4 crimes to the Big 12 and why the Senate did it last year. These are crimes that are associated with drug trafficking, with the exception of aggravated stalking, are involving drug trafficking and involving some pretty violent individuals who, particularly the human trafficking area, the regulated trafficking of the drug firearm while committing a felony. I'm perfectly willing to have further discussions about how to shield some of the record, but I personally I think it's important that we start to treat some of these crimes that are happening in our state. And how to shield is fine. Talking about 14 and 15-year-olds, that's fine. But the whole idea, I don't know how difficult it is to transfer up. I have a sense that it's more difficult than transferring down.
I could get more information about transferring down from folks in the field. I asked about transfer up, given the interest last time. Yeah, I could certainly follow up with you on that. One thing
I do think that you should redefine burglary into an occupied dwelling. I always thought it was a permanently occupied, not somebody breaks into a camp up at Sucker Pond in Stanford. I don't know if they should. I'm not even sure which town Sucker Pond is in.
Never heard of it.
It's up on the hill. It's an interesting name, but there's several camps up there and it's in the national forest. Somebody breaking into one of those camps, I don't think the intent is the same as breaking into somebody's home.
As to the recommendations in your bill, they're in alignment with the executive committee's recommendation of state's attorneys, and the conversations that took place amongst the Attorney General's office, executive committee of state's attorneys.
The Attorney General supports this now?
The Attorney General's office signed off on our recommendation to expand the Big 12.
Last year they were opposed.
As of the Sentencing Commission conversations, I'll let them speak for themselves, but
We should have the Attorney General.
the recommendation we had, which included the inclusions that you put in this bill, were in our recommendation, and they informed Judge Zone they were in support of those expansions.
Okay, that would be a change.
But so that group, the coalition that had worked on that recommendation included Crime Victim Services, Department of Public Safety, the Executive Committee of State's Attorneys, and the Attorney General's office informed Judge Zone they were in support.
Okay. Senator Rashid, you had a question.
No, it was some comments about burglary, but I think that's probably for another conversation later on.
Anything else?
One comment I wanted to make, as you included in some of your bills last year, is a severability clause, because there is some potential for litigation as to some of this, I would presume. That it may be important to include that. And also, this is out of my pay grade, but I was thinking about it from another conversation. Specific references to federal law, making sure that if those federal codes change, that the language doesn't become out of date. Evan Mean and our appellate attorney flagged that this morning.
We don't do that.
Okay. I just wanted to flag it for drafting purposes. Other than that, I don't really have any other comments, and thanks for your time this morning.
Yeah, and if you can get us some of that information from Bennington, Rutland, and Addison County, and any place else.
Yeah, I will reach out to those folks.
Section 2 of the bill.
Thank you.
Any other? Marshall Paul?
No,
I know it's a topic.
there is.
Did you have? Marshall, welcome back. We missed you last year.
I was here last year, that's, at the end, I got pretty sick, and I'm pretty sick today, but hopefully you'll all be able to understand me. If at any point you can't, just let me know, and I'll try again.
Can I ask just for clarity, have you tested? for
Yes, it's not COVID, it's something else, but,
That sounds horrible.
It really does.
no, it's awful.
To be honest, it's,
Yeah, no, it's not good. It's not good.
thanks, man.
Thank you very much, Mr. Chair.
So, our testimony this year is similar to our testimony from last year, which is that we oppose the expansion of the Big 12, and we oppose that for a number of reasons, systemic, as well as specific to the offenses that are being considered. Systemically, there's zero evidence that presumptive adult court for a 14-year-old kid is ever going to benefit anyone. And that's in terms of whether it's not going to be better rehabilitative for the child, and it's also going to be worse for public safety. And this is actually an issue that's been studied really extensively since at least the 1970s. The question of, is public safety protected more if children, and particularly children who are accused of having committed violent or serious interpersonal offenses, are treated in juvenile court or in adult court? And the answer, unanimously in every study, has been that it's actually worse for public safety to put them in the adult court process. They are more likely to come out of that process and commit more crimes and more serious crimes than if they're in the juvenile court process. I submitted to the website a number of studies. I know that studies can be pretty tedious to read because they are lengthy and include a lot of stuff. So what I've done is, I'll pass these around. I've excerpted from each of the studies just the abstract or conclusions or summary of the study that speaks to the issue of recidivism and the issue of safety in terms of children being treated as adults. So, so all of that is to say that even children who have committed the most heinous acts, violent interpersonal acts, they are less likely to go on to commit further violent, heinous acts if they are kept in the juvenile justice system as opposed to the adult justice system. And that is essentially an undisputed conclusion. Now, I do want to sort of dispute a few of the statements that the state's attorneys made. I think some of it was just a little bit incorrect. Like, for example, talking about the adult court system as being more expedient than the juvenile court system, especially when it comes to things like conditions of release and the immediate ability to lock someone up. The adult system is not more expedient than the juvenile system in that sense, and in fact, it very well may run a little bit slower than the juvenile system. If you remember that the juvenile system during the pandemic, we kept running along. Adult court trials ground to a halt, motion practice slowed down to nothing, and the courtrooms were not open. But the juvenile court system stayed open the whole time. And that means that there's less of a backlog in the juvenile system now than there is in the adult system. So for one thing, it's easier to get a court date in juvenile court than in adult court. Besides that, the juvenile system is already very experienced with expediency. We do things like issue flash cites, which allow for a juvenile to be arraigned the very next day. And of course, the powers of arrest are still there, and so juveniles can be arrested. There was some questions about, well, what happens when a juvenile is arrested? Because for the past few years, we've had this difficulty that when we have kids who are in a severe state of crisis or dysregulation, we don't have a secure place to put them. According to DCF, that problem is remedied by the end of this month. They're currently renovating the Middlesex facility, and that will be open, and that will provide 4 secure beds that'll be available by the end of the month. And so that gets to our specific concerns about that's all right. To our specific concerns about the identified felonies that we're talking about adding to the Big 12.
Can I ask a quick question? I mean, one of my thoughts is going to the hold without bail issue. So are you saying that if a juvenile is charged with murder and the state meets the thresholds in 7553, that juvenile will be able to go to that facility that DCF is putting up by the end of the month?
Well, that's an interesting question. If they were charged in juvenile court, the answer is yes. If they're charged in adult court, the answer is we don't know. Okay. Under the old system, DOC and DCF had a memorandum of understanding that allowed DOC to place youth who are in DOC custody in Woodside, but it didn't require DCF to accept those kids. So, for example, what would happen sometimes is DOC would ask to place a youth at Woodside, and DCF would say no, because either Woodside was full or they didn't feel like the youth was appropriate for Woodside. At the time, those youth would simply be placed in adult facilities. Now, one of the things that's happened in the intervening period here is that the federal government has come down hard on the states to say, you should not be mixing youth with adults in prisons. And so they, in 2018, reauthorized the Juvenile Justice Delinquency Prevention Act. And as part of that reauthorization, they made it illegal for states to place juveniles in adult correctional facilities unless they go through this process called an interest of justice hearing, which is another piece that slows down the process. And the interest of justice hearing requires the state to prove that it's in the interest of justice for that particular youth to be held in an adult facility among adults. That's actually a really hard burden. The federal law lays out a list of criteria, and those criteria are clearly slanted at trying to keep youth out of adult facilities. And that's because of the US Congress, in reauthorizing the JJDPA, looked through the same kind of research that I just presented to you and said, wait, it's a terrible idea for us to put young people in adult jails. That results in more crime, not less crime. So let's try to pressure states to say, you can't do that anymore. And so they've really limited the ability to take a juvenile and put them in an adult prison, even if they're charged as an adult. So I would say that. Another thing, just while I'm addressing that, there's been sort of this repeated mention of, what about the idea of a closed courtroom, a closed adult courtroom for young, youthful adult offenders. Everybody keeps bringing that up. It was brought up by the administration last year. It's brought up by the state's attorneys this year. It's been held to be completely unconstitutional by the Second Circuit. So it's it's within our jurisdiction. We have no ability to do that. It was actually a violation of the First Amendment. It was a case called the Hartford Current versus a long list of people. I think the Hartford Current sued every judge in the state of Connecticut. Because Connecticut, when they were engaging in their raise the age legislation process, that's one of the things they did first, is they said, let's make it so that everybody who's under the age of, I think they used 22 or 25, when they're in criminal court, it's a closed courtroom. It's not open to the public. It's not open to the press. The press sued, and the Second Circuit ruled that because criminal court is a traditionally open environment, you can't wholesale close it off for an entire category of people, of criminal defendants. You can if you're in juvenile court, because that's not a traditionally open forum. So that's really just not a possibility, as much as I sympathize, because I think it's a great thought for a solution to this kind of problem. It's just not a constitutional one. And unfortunately, the court that's ruled on that is our own Second Circuit. So we can't even, say, well, that's another circuit. We don't have to worry about it. So, excuse me. I do want to talk about the offenses. In particular, I want to talk about drug trafficking and human trafficking to start with. Because any 14-year-old, even if they've committed the elements of human trafficking is an incredibly serious and incredibly dangerous and incredibly complicated and sophisticated crime. And the way that our law is written, it's certainly possible for someone who's 14 years old and who has been caught up in a human trafficking situation to commit all the elements of human trafficking. That does not mean they are a human trafficker. That means they are a victim of human trafficking who's been forced to break the law in the course of being a victim of human trafficking. The same as I would say is true of drug trafficking. It used to, we drug trafficking by weight and weight alone. If someone is caught with 1/8 of an ounce of heroin, there's a presumption that they are a drug trafficker and they can be charged as a drug trafficker. 1/8 of an ounce of heroin to begin with is not very much heroin. According to my clients, that's the first weight at which you receive a discount of any kind. So just to begin with, if you're trying to be frugal with your money and and multiple users pool their money together to buy an 1/8 instead of buying stamp bag by stamp bag, 3.5 grams is an 1/8. You've committed drug trafficking. Now, that is not the kind of drug trafficking that the statute was initially meant to go after. It was meant to go after the types of drug kingpins. For example, there was an article in, I think, CAX last week about a federal prosecution of a drug trafficker in Vermont. Juwan Williams, I think was his name. And when they described what he did, that was drug trafficking. That was a man who ran a network of drug distribution sales across 3 different states using many, many different people as couriers, as salesmen, as people to run money, as people to move guns. That was drug trafficking. That's the kind of sort of sophisticated, complex organization that statute was meant to go after. The 14-year-old kids who are holding on to 3.5 grams of heroin on behalf of somebody else are not the drug traffickers that the statute was meant to go after, and they certainly don't belong in adult court as a presumption just because they got caught up in that. If anything, they are victims of the drug trafficking organization. they are not drug traffickers.
Thank you, Marshall. To this point, so we heard yesterday from a witness who works with youth that a lot of these sort of criminal enterprises and adult drug traffickers actually target poor communities, disenfranchised communities. I wonder if you have any data, or if maybe the director of racial justice would be able to bring this data around the sort of the racial data around who is being targeted in these types of cases and how increasing the filing into adult court, what racial or economic impacts that might. Does my question make sense? I don't feel like I'm being very clear.
Yes,
Okay.
I think your question does make sense. I don't have any of that data. We've been trying to find that data. It's actually really difficult to find. I don't think anybody's really collecting it at this point. I would say that there's national data, which is actually highlighted in the materials I provided, that show that there, in terms of states where there's discretionary transfer decisions, so where people can be transferred up from juvenile court to adult court, they do see racial disparities in that data. That's national. I would not be surprised if we saw those national trends mirrored in Vermont, because typically though we often consider ourselves sort of an outlier and separate from the rest of the country, we really see the same trends here as we see elsewhere. I also wanted to talk about the crime of possessing a firearm while during the commission of a felony. To begin with, this is just a characteristic of youth, is that adolescents, and when I say adolescents, I mean children aged 12 to 25, but the particular range I'm talking about here are children aged 12 to 18, because those are the ones that were part of the youth risk behavior study, which is one of the most well-respected, well-validated longitudinal studies of risky youth behavior. And that study shows that 1 out of 5 youth have carried a weapon, self-reported, having carried a weapon within the last month. And typically, children who carry weapons don't actually have a plan to use them or an intent to use them. They carry weapons for various reasons, some of which is that they're simply mirroring behavior that they see around them. If children grow up in households with people who carry weapons, they are likely themselves to carry weapons. Another factor that has been shown to be very closely correlated with children carrying weapons is children who have witnessed or experienced violence themselves. Children who grow up in environments that feel unsafe carry weapons with them. And while I would not have the same concern if what the bill said was that we were concerned about youth who use firearms in the commission of a crime, I worry more about the youth who are carrying a weapon without any intent to use it. So, for example, if a kid gets caught spray painting graffiti under a bridge, which is a felony because apparently you can't spray paint anything without doing more than $900 worth of damage. Shockingly, that $900 figure has never been adjusted with inflation. And these days, getting somebody to paint over graffiti ends up costing more than $900. So, kid who's spray painting with graffiti under a bridge who has a gun in their backpack, that would be an automatic adult court felony under this law. Or, for example, a young person who's going deer hunting who also commits another bad offense, which is that they drink and are driving home and commit a felony DUI with a deer rifle in the back of their trunk. That would also be an automatic adult court placement in adult court for that youth. So
It'll be automatic if the state's attorney decides to charge.
I think there's this sort of concept about.
If you're 16 years old and you're driving drunk, and you happen to have a firearm in your backpack, I don't know what the state's attorney would do, but I suspect many of them would charge you, so it's their choice.
They don't actually have a choice.
Pardon me?
They don't actually have a choice. The Big 12 doesn't give people a choice. When a crime is a Big 12 offense, prosecutors have no choice but to charge it in adult court. Now, what Tim was referring to when he said that prosecutors directly file in the juvenile court is something else. It's not actually, they're not allowed.
You're telling me they can't directly file in juvenile court?
They'll directly file as youthful offender, and that's different, because youthful offender is an adult status. It has an adult penalty on it, and you have to waive your rights to a jury trial, and you have to waive your right to a public proceeding. In order to proceed.
But I'm talking about persons arrested
Yes,
for DUI. They're 16 years old, and there happens to be a firearm in the backpack. Does that automatically get charged in the first place? And does it automatically get charged as an adult offense?
any prosecutor can decline to charge anything they want to decline to charge.
So the state attorney could ignore the firearm in the backpack.
They could. And that would be leaving up.
That's my only point, Marshall.
That would be leaving it up to prosecutorial discretion. There was a study that was done quite a while ago, back when prosecutors had the discretion to charge anybody between 16 and 18 in any court they wanted for any crime they wanted. There was a survey done of all the prosecutors to get a sense of their attitudes toward charging.
Yeah, but my only point is just that they don't have to charge the carrying a firearm.
It's true, but what a lot of the state's attorneys said when they were polled was so it ranged from some counties that said, literally, we exercise no discretion. All charges that can be charged in adult court are charged in adult court, to the exact opposite end of the spectrum, where we had some state's attorneys saying, anything that I can charge in juvenile court, I do charge in juvenile court. And so the difference between whether you were treated as an adult or a juvenile, whether your name and picture was in the paper and on the news or not, would have to do with, are you on this side of a county border or that side of a county border? It's a prosecutorial discretion is really never it's never solved any of the kinds of problems that we're looking to solve.
Good.
So I think I will leave my testimony there on that piece. And just discuss, our proposal, the two proposals that we made in the Sentencing Commission were, first of all, to eliminate the Big 12 altogether, charge everything in juvenile court, and then make the decision, should this be transferred up? Should this remain in juvenile court, or should this go to be a youthful offender case? There's a lot of reason for that. One of the reasons is our system right now is extraordinarily complicated. There's 3 different types of transfers that can be made. A transfer from adult court to juvenile court, a transfer from adult court to youthful offender status, and a transfer from juvenile court to adult court. Each one of those types of transfers uses completely different criteria for no reason at all. And what it really reflects is when those laws were written. So the transferring from adult to juvenile court, in statute, there are no criteria. So the Vermont Supreme Court adopted criteria, and they adopted the Kent criteria that were written by the US Supreme Court in 1967 and reflect sort of the understanding of adolescent brain development that we had in 1967. For transferring from adult court to youthful offender, we have a different set of criteria that was written in 1999 when we developed youthful offender. That uses a sort of an understanding of adolescent brain science that we had in 1999. And then finally, we have the criteria for transferring from juvenile up to adult court. And that uses yet another set of criteria that was written, I think around 2009, 2007 with the rewrite of the JPA, and that reflects the understanding of adolescent brain development that we had then. And so really, it's a very complicated system with multiple layers of different types of transfers, different procedures for transfers, and different criteria to make decisions about those transfers.
I understand. Can I just comment, Marshall? Frankly, one of the reasons we left the Big 12 intact when we did the raise the age, which I think is the right thing to do, or was the right thing to do, and was because of the public reaction to certain things that you do. I represent people. And to come back and justify what we did, I needed to better explain. I'm still getting hassled about that law. The fact that the administration would want to hold off the 19-year-olds for another year, or actually indefinitely until they have programs in place, is also a great concern to me. Because it isn't keeping the commitment or raise the age, but I think the public would, it'd be very difficult to explain why a murder case would not start in adult court, whether it be a 15 or 16-year-old. I'd have a hard time justifying that to my constituents and understand that. I also am more than willing to look at the drug trafficking you just described and make sure it's the type of case that really rises to that level. But carrying a firearm, maybe it should be the use of a firearm in the commission of a felony. Could we agree that that's fairly serious? If you're actually using it, whether it's pointing at somebody or putting it on the counter and saying, if you don't do this, I'm going to use this, or I'm shooting you with that firearm, like we had in Bennington. It wasn't a youngster, it was an older person who somebody was trying to flee because they owed the drug dealer money, and the drug dealer shot him in the leg. Luckily, just in the leg and didn't kill him. But so I'm willing to look at that because it was really the use of a firearm in the commission of a felony. So I just want to make that clear from my perspective. I'm only one of 5 members of this committee. I happen to chair the committee, but I have a hard time trying to go back to reestablishing, and we're going to have long arguments about whether or not I think we'd have a protracted argument. I'm also interested in making clear that number 12 is really an occupied building. And I don't know what the language would be. If you could help myself and Eric on that language, I think it's important to clarify that so that somebody isn't charged for happening to go in to try to get a bottle of liquor out of the deer camp.
I can help with that. My only comment on the Big 12 would be this, is that a couple things. One is 14 years old is really, really young. We currently have a 14-year-old charged with murder, and that did not simplify anything. It made everything much more difficult. And part of that is because of what's happened federally in between when we passed raise the age and now. The federal government has taken, they're starting to take the same steps that our state took, and was saying to all the states, you need to get kids out of adult facilities, you need to get kids out of the adult system. And so, for example, the case that currently is pending with a 14-year-old who's charged as an adult with murder in adult court. That was a case where it was it was extraordinarily difficult at arraignment because nobody could answer questions about what would happen to the kid if the kid stayed in custody. And in fact, there was a testimony from DOC that the only thing they could do if that child was held without bail, and held in DOC custody, is they would have to truly segregate that kid, put them in solitary confinement, which they don't even do to adults. Even the worst adult prisoners, they get put in SEG, which is different than solitary. SEG still gives you a half an hour of human contact per day, plus it allows you to eat your meals with other people and have contact with other people who are in SEG. Under the only thing that DOC could do was literally to put the kid into isolation, which is incredibly damaging. So I think part of this is not just sort of the development of Vermont's own process, but the development of our process with the pressure from the feds.
Yeah, we can require the MOU that was existing at Woodside.
And I think the other piece of
I
that,
think
though,
we did that years ago, I believe. Statutory.
yeah, that MOU was never effective in the sense that what would happen, and I see this as someone who represented all the kids at Woodside during the time when the MOU was in place, is if Woodside reached capacity, then all the
I'm
kids.
sorry, I couldn't understand.
So when I represented all the kids at Woodside,
Yeah,
and the MOU was in place, whenever Woodside reached capacity, which it did on a regular basis, the first thing they did was kick all the DOC kids back out to DOC. Similarly, when they had a kid who was there under the MOU who presented behavioral challenges or any other kind of challenges, they would kick them out and send them back to DOC. So from our perspective, it was probably a good population management tool for DOC, but it didn't benefit the kids at all.
you got it. But we can make that clear in the language regarding the MOU.
My other suggestion, and this is sort of the
Tanya, Senator Wahalski.
Yeah, thank you. I have just a comment. So the case of the 14-year-old that you're talking about is in my community, and the outcry has actually been that we should never be charging children as adults. That is all I have heard. People are horrified that this has happened and this 14-year-old has been charged. And my understanding from the people I've spoken to is even the victim's family has expressed concern. So I think that there certainly, I hear the concern around the community response, but I think when we see what it actually means for a 14-year-old to be charged, the community is actually pretty shocked. And that has been my experience, given in this particular case being in my community.
I would agree with that. That's been what we have heard in our office from the community. There's been a lot of outrage that that was charged that way, but frankly, I don't think the prosecutor had a choice but to charge it the way that she charged it. The other thing that I would just add, and this goes to Senator Sears' point about the tension that we're talking about, is that's why we added the proposal in the Sentencing Commission, because it was clear that there was zero agreement as to whether to expand the Big 12 or whether to shrink the Big 12. And that's why I said at one point, you know what, maybe we should leave the Big 12 alone because we can't come to any consensus, but instead we should raise the applicability of it from age 14 to age 16 or 18, in whichever case, raise the applicability of it. And there was a lot more agreement around that than there was around any question of adding or subtracting from the Big 12.
Anything else?
Nothing else here.
Thank you, Marshall. Hope you get better soon.
Oh, me too. I'm already getting better.
You're already getting better, I know. Thank you very much. Eric, can you join us for a second? I think I'm getting a sense of. Obviously, whoop. we've got a lot of witnesses still to come on this. Frankly, some things take me by surprise, and our opposition to the firearms piece takes me by somewhat surprise. I'm not surprised at opposition to the Big 12. But if we could, are there any things in this people that you would like to hear from, or specific areas in section 2 that you'd like to hear more about next week? I know we've got a number of witnesses to get to. Section 2 is the so-called ghost.
Thank you.
Are we hearing from an FFL?
We're hearing from, we've got the Vermont Federation of Sportsmen, the NRA, and our student gun owners will on at some point. We'll also hear from somebody from the Gifted Center. I don't know if we have anybody that.
An actual
Federally
licensed
licensed
dealer. Yeah,
Yeah, that would be
that's
interesting.
technical questions, but
Do you have anybody that?
Yeah, absolutely. I
Okay,
have several people.
Give the name, well, one.
Yes, I'd suggest Henry Carroll, of Carroll's Venture,
Okay.
Columbus.
In Montpelier,
No, that's more.
Barry.
That's more.
the reason I suggest is just it seems like a lot focused on FFLs, and I think it would be good to hear about the actual
Could you give
implementation.
Ben the contact information?
Absolutely, yes, sir.
Please. Anybody else? Yeah.
I was just curious when it comes to the non-serialized firearms and our first line defense that we have in the state of Vermont, such as chiefs of police, state sheriffs, anybody as to what their take is on this particular bill. They're the ones that are gonna run into it before any of us are, so. Good, bad, or indifferent, I don't know what their take is on it, so.
Could ask the state police, or could ask the Vermont Chiefs Association, or we could ask the Bennington. Why don't we ask, we had a call in a Sheriff Gully on this.
So the sheriff from Bennington was supposed to testify today, but was unable to, but he wants to testify at a later date, so I plan to contact him when he is
Would
available.
that be satisfactory?
Well, he has experience with the ghost guns, so that certainly hit that aspect of it. I was thinking more along the lines, like Ron Hoyt, the chief out of Essex. He's the president of the Chiefs of Police Association. Just one from the sheriff, one from the chief, that'd be great.
So, we can do that.
I can get you Ron's information, because that's my police chief.
Oh, it's your people, your people.
Yeah,
Okay, if you get that to
I
Ben.
can.
Not to just keep adding to it, but going off of what Senator Norris said, sounds like there's also conversation about how this is tied to drug trafficking. Do we want to hear from Drug Task Force too?
Well, we could hear from Casey, what was his name?
Casey Daniel.
Casey Daniels.
So my request is actually to hear from the director of racial equity, but on the whole bill. I
Oh,
think
but let's, this piece?
on both pieces. So I'd like to get in the habit, if we're creating new crimes or changing the way crimes are instituted, of hearing from the Department of Racial Equity on what, if any, racial impact it will have. So so the whole thing, I'd like to hear from them on both pieces, and if that waits until later, that's fine. Yeah.
Okay. If they wish.
If they wish, if they choose not to, that's fine too.
I'm not sure they have any position on serialized firearms. They probably have a position on the Big 12.
And they may not, and that's fine. I just, knowing our lengthy history of crime that has disparate impact, I just want to get in the habit of asking them.
Well, Ben has to contact him. I just want to get Ben away.
Yeah.
All right, so Eric, we can work on language of Marshall on number 12, the burglary into an occupied dwelling. and number 13, which would change it to the use of the firearm in the commission of felony. Take care of the backpack. But I don't know what the language would be.
Yeah, I was looking at the burglary statute while you were discussing it and take some thought, I think. It's interesting, just if I'm understanding. So the
Well, it's
intent
been
is.
bothering me for 30 years. So, I mean, I think it's been a constant wondering how, once years ago, we looked at burglary into an occupied dwelling, the statute itself, and I think it was during expungement. And I believe that we settled on if you were under 25 and you was a burglary into an occupied dwelling, you could get your record expunged.
Yeah, we do have statutory language to that effect,
But
somewhere in the expungement section.
And we've been playing around with this for years, and we've never really, I mean, one would assume that the building was occupied in order to be charged with it. It says occupied building.
But it defines occupied dwelling to be a dwelling that I think is ordinarily occupied or something like that.
Right.
And again, it can be, doesn't have to be full-time.
Well, I mean,
Can be
for
part-time.
what is the, maybe the Big 12 should be if you break into a dwelling that is currently occupied.
Mhm.
That's where the danger comes, either the occupant or, I've often told the story about the kid that didn't break into the store, he just leaned against the door and it opened. So it wasn't a break.
But he wasn't supposed to be there.
No, he didn't think that
Yeah.
was a real break. He didn't tell me how hard he leaned against the door. I was suspicious it was a pretty heavy lean. And trafficking of regulated drugs. You know what? That isn't critical. We'll let the committee decide what to do with that, whether we change it or. Human trafficking is very real in my area. And let's hear from Jennifer Pullman on aggravated stalking. Anybody? And that number 16. Anybody else with any ideas of who you want to hear? All right. We need to continue to deal with bail. We have another bail bill that came in, Senator Norris introduced, along with others. So now we have 3 bail bills to work from. I was talking to Senator Hashim and Ben today, and I think the best course of action is to combine all 3 into one bail bill.
Should
But
they
who knows
go
where
through
we'll
one?
go. Well, but I mean, we have 3 to work from, so we should deal with bail. We have S-58, which is the federal to deal with. Those are 3 priorities. Then we have the big oil, which I hate that name. Really, should there be strict liability for polluters? That's the real issue. And we have the constitutional amendment, PR4. To do, and a few other bills. So we've got a busy 6 weeks ahead of us. But I think we should try to do the constitutional amendment. And then one of the things in terms of the bill on strict liability, Michael Grady is a pretty busy legislative council member, not that Eric and others aren't. Mike is sometimes hard to pin down because he's in a lot of different committees. So if you could work with him on the first week of February, the first real week of February,
Do we have?
Like the fifth, what days he might have available.
Yeah, sure.
I
haven't seen it.
I don't think we've talked about it yet, so it may not be in our folders.
What's that?
Senator Norris was asking if we had received, a physical copy of Prop 4 yet.
I have not printed one out yet, but I can do that.
Oh, we have it, it's been here since last year.
But we haven't talked about it, so
We haven't talked about it.
Somebody asked me about it, so I haven't heard of it.
Yeah, no, I know, I think we all got emails yesterday from somebody in Moncton,
Yes.
which I thought would be more appropriate if Senator Hardy and Senator Gray responded to them. Anything else for Eric?
I had a question, and I may not remember this correctly in the statute, so I sort of hesitant to bring it up. But I remember when one of the concerns that you've been discussing with respect to the Big 12 expansion posed in 209 was the possible sweeping in of human trafficking victims. And I seem to recall, I could have this wrong, but I thought the human trafficking statute also had an exemption for victims. Maybe there's a way you could cross-reference that or something
I
to
think
make clear.
Michelle did that,
Yeah,
you may wanna just run it by her,
right. Might be a way to try and limit the
Yeah.
length so that it,
make sure that it doesn't
right,
encompass the victim.
right.
Just with the amount of witnesses that were just named for S209, we are gonna have to hear it. We already had the full list slotted for next week, so we will most likely have to do another meeting on it the following week, which is I believe the week of the.
Okay, that, the only day that's problematic there for me is the first, so we could schedule the bail bills on the first. I have an operation first of February. It's outpatient, so I'll be fine for second, but it'll be remote. I'm supposed to stay quiet for 5 days after the operation.
Can you do that?
No, I probably shouldn't drive to Montpelier.
Fair.
All right. So thank you all very much.